All right, the final case set for argument this morning is case numbers 18CA011350 and 18CA011351, Melva Sherwood versus Lindsey Eberhardt. And both sides are present. How many people will be arguing for the appellants? Both of you, so you can split your time between you. You have 15 minutes. Each side will have 15 minutes, and the appellant may have up to 5 minutes for rebuttal. There are children that are involved in this case, so the court's rule is that we refer to them, and you're to refer to them by initials, not by names, since we do videotape and post the arguments on our YouTube channel. Other than that, we have read the briefs and we are prepared to proceed. How do you want to divide your time up? Have you decided that?
Yeah, I would like to go first. I don't think I'm going to use 5 minutes. So.
And then the balance.
Mr. Gorilla,
Okay.
do something.
And what about rebuttal? Are you going to?
I would like to take that if necessary.
How long?
3 minutes.
3 minutes. All right, you may proceed.
Thank you. Good morning. My name is Jonathan Rosenbaum. It's my honor to appear with Mr. Gorilla before you on behalf of Lindsey Eberhardt. In our third assignment of error, we suggested that the trial court did not have jurisdiction to entertain any of these motions. We respectfully submit in light of this court's decision in Re CW 2018 Ohio 5265 that there is no judgment to seek relief from, and that this appeal is also moot as a result of that. We also argue that the trial court erred when it failed to dismiss and in sustaining the motion for relief from judgment because the motion and the proof failed to comply with the requisites of Ohio Civil Rule 60. For a fraud to for a party to seek or obtain relief from a judgment based upon fraud, it must either prove that that fraud was upon the court or upon one of the parties. For the fraud to be successful or to be substantiated for the party, it has to prove, that party has to prove that it was denied the ability to prevent its case or defense. In this case, no such thing happened. The Sherwoods were free and did argue prior to the hearing or at the trial and during the motion on the GAL fees that the GAL was impartial. It said every bad thing that it wanted to say about the GAL fee and the GAL to no avail. To claim then that there's a new reason as to why the GAL was biased when the trial court and the magistrate both in well-reasoned and factually supported opinions said that that everybody had its day in court and that the GAL fees were justified. That does not justify having them take another bite at the apple in a motion for relief from judgment. The Sherwoods clearly had their chance to present all the evidence they wanted. The trial court and the magistrate made an independent assessment. There could be no fraud upon the court when the GAL said nothing that wasn't admitted to by Melva Sherwood. That's got to be dispositive of this issue. Also, regarding the fraud upon the court said it made an independent judgment. The court was able to make an independent judgment. There are no facts in the record other than the bold claim of reprehensible conduct that support the belief that the court did anything other than make an intellectually independent finding that the GAL fee was proper to begin with. There's nothing before the court that would justify it changing its mind as it did. We also argue that the trial court abused its discretion in reversing its opinion regarding the GAL fees without taking a shred of evidence. You would think that common sense would dictate that if this reprehensible conduct took place and it tainted the judgment of the GAL at that time, that someone would afford either the GAL or the moving party the opportunity to offer evidence as to when this reprehensible conduct began. But the trial court, at every step of the way when Lindsey Eberhardt desired to offer evidence on any issue, decided to cancel the evidentiary hearing and made some sort of legal ruling some sort of justification for that ruling. Which brings us to our final assignment of error that we want to argue this morning, that, I guess it's not the final one, but anyways, moving on to the discovery issues, we respectfully submit to this court that the convoluted reasoning that the trial court took regarding the discovery issues to justify not having an evidentiary hearing is refuted by a mere reading of the rules that apply. The juvenile rule 25 clearly provides when depositions can be had in a case, and assuming even this was one of those cases that the depositions would be proper for, depositions are only to be taken when they're to preserve testimony, and that there was no argument that it was needed in this case. The discovery orders were invalid and any sanctions for violating them while a motion to quash was pending. The trial court acted as if Lindsey Eberhardt ignored the discovery request. She filed a timely motion to quash, which was never heard, never afforded a hearing either by Judge Janet. And finally, we say that Rule 25 does not apply because there was no disposition in this case to justify the taking of depositions. Any disposition in this case was vacated by this court's decision in N. Ray CW. Thank you.
Okay, thank you. Okay, going to argue as well, go ahead.
Thank you, Aaron. May it please the court, my name is James Barilla. I'm I'm pro se, former guardian ad litem in this matter. I'm not going to duplicate statements that my associate counsel has made, but I want to talk about a couple of jurisdictional issues. This court has previously determined in this case that there was no exercise of jurisdiction in 2011, and that there was that the exercise of jurisdiction in 2016 was void. It would be the Sherwood's position filing a motion, not a new complaint in a new case, filing a motion in an action that the court's never exercised jurisdiction would be an inappropriate vehicle, and that the trial court had no jurisdiction to appoint a GAO. I think everything that happened after 2011 is void. In the original decision, the court didn't address that issue because it wasn't before them. Because the custody action and the visitation action by the Sherwoods had been dismissed prior to the visitation trial. So I would say that should never have been appointed GAO. And secondly, jurisdictionally, there were several appeals pending before this court. I had been removed as Lindsey Eberhardt's trial counsel while the remand, just during the remand, there was a writ prohibition pending, and there was I refer to it as appeal that ends in 325. I had taken an interlocutory appeal because it appeared the court had already ruled on the 60B, because there was an entry saying a reconsideration of the GAO fees without having a hearing. So that appeal, all those appeals were pending when the court ruled on this, and the Court of Appeals would have had jurisdiction on all those issues. The remand was only in the original 4-4 appeal and the GAO fees, and I don't think the trial court had jurisdiction to do anything that did. Lastly, briefly talk about this res judicata argument, because I put it in my reply brief, but I want to feather it out a little bit more. Mr. English, on behalf of his clients, filed a motion in July of 2016 saying that, for a whole host of reasons, that I should be removed as a guardian ad litem. That was briefed. The court ruled that I should not be removed as a guardian ad litem, and that wasn't appealed, and it was dismissed. Mr. English, on behalf of his client, dismissed his case. So he can't. That was his time to litigate. It would have been to appeal the denial of his motion to remove me that would have been August 22nd, 2016. On September 7th, 2016, I was actually removed as operation of law because his case had been dismissed. An operation of law actually should have happened when he gave the dismissal, but, which was the 29th, but it was actually September 7th, the court journalized it. So that leaves a very small window of opportunity for them to argue that I committed any kind of fraud, which I did not. The rules to file for relief from judgment for fraud under section C, or 3, says you have to do so within a year. He filed in November of 2017, which would have been a year from November of 2016, which would have been outside that window. So I'm not sure what he's arguing on behalf of the Sherwoods, but all the arguments that he made were made many times in 2016. They were made in his motion to have me removed as GAL. They were made in his arguments regarding GAL fees before the magistrate, and they were again argued before the judge in the objection process. So he had ample opportunity to make all of these arguments, and as counsel previously said, the court made independent findings. I never provided any testimony when I was actually the GAL. I provided testimony in a hearing that has since been determined by this court to have been void. But I gave testimony in September of 2016 after I was removed as GAL. But there's nothing that in that testimony that was inconsistent with what Ms. Sherwood testified to. Lastly, it seems that this process is going to have a chilling effect on GALs. It's difficult enough to find qualified good GALs who are willing to work at a lesser rate to protect children. In this particular case, I had over 100 hours in a case that I had put in my GAL initial report indicating that I didn't believe the court had jurisdiction. And the court implored me and directed me to keep working, to keep generating hours that I perceived to be unnecessary. And that total fee was $17,000 after 6 months of work. And one deposition that was missed, it took away $17,000 in GAL fees and sanctioned me $8,000 for going to a deposition that there was no authority to have. There's nothing in the rules that provides, in juvenile rules, that provides that I would, as a non-party, would be subject to a deposition in a non-parentage action unless it was leave of court. And no leave of court was granted or requested. And even if I didn't appear, a motion to compel or some sort of vehicle would have been necessary before I could be sanctioned financially, or as the court did, determine that I committed fraud by not attending a deposition. And I would ask this court to take notice that that would have a very chilling effect on future GAL work if the courts, they were $8,000 in sanctions for 1 day versus $17,000 versus 6 months. Thank you.
All right, thank you. Counsel, you'll have 15 minutes.
Thank you, Your Honor. May it please the court, Your Honor, my name is Brent English. I represent Melva and Scott Sherwood, who are the appellees in these 2 appeals. I want to first focus on what Mr. Gorilla just claimed, which was a remarkable proposition. As I understood what his argument was, that a trial court could not ever issue sanctions against a GAL despite his misconduct because that would have a chilling effect on other guardians ad litem performing their work in an honest way with integrity. I submit that proposition is as preposterous as the conduct in this case. So while there are many misstatements of fact that have been made so far, let me remind the court what the actual facts were. First of all, in November of 2011, the parties reached an agreement, and that agreement was memorialized in a judgment entry by the former trial judge, Judge Baczynski. And this court specifically held in In re CW and BW, the case to which Mr. Rosenbaum and Mr. Gorilla refer, that the challenge on jurisdiction with respect to that order was invalid. they have somehow transmuted this idea that the court did not have jurisdiction in 2016 to the proposition that the court did not have jurisdiction in 2011. And I respectfully submit that that is dead wrong. So there was, in fact, a judgment entry that granted my clients a grandparent visitation with their grandchildren, CW and BW, starting in 2011, which they had faithfully exercised. The issue that arises from these appeals is whether or not a granting of a motion for relief from judgment and attendant sanctions for failing to comply with discovery and engaging in the fraudulent conduct that in fact we allege and we believe the record shows is somehow improper. So with respect to Mr. Barillo, one of the things that I think needs to be recognized is that the court made a determination, the trial court made a determination based upon the evidence that Mr. Barillo, remarkably, as a lawyer and a guardian ad litem, had an improper relationship with one of the parties to the underlying case. It is hard to say that out loud, to understand how a lawyer can come here and say somehow there is a chilling effect of a judgment like this when those are the facts. He contends in his brief that he didn't have such an improper relationship. Well, the trial court found that he did, and based upon the evidence that is in the record, I would respectfully submit that the record shows that. Moreover, the idea that somehow when a court orders that depositions can take place and parties decide they are just not going to show up, that they cannot somehow be sanctioned for that conduct defies logic, and moreover, it is completely not supported by the law. Civil Rule 37D specifically provides for such sanctions, and so does Juvenile Rule 24C. That is exactly what happened in this case. This case has juvenile jurisdiction only because it relates to grandparent visitation that started out with non-married parties. But nevertheless, the grandparent visitation is a juvenile issue, at least the way it's presented in this case. And so the court had the ability to order that depositions be taken, and in fact permitted that exactly to occur. It's right in the record. So for them to come here today and say, well, the court didn't have any authority to do that, that just defies logic, and that's not exactly what the rules say. In fact, it's precisely the opposite of what they say. So the idea that somehow the trial judge got this wrong is something that the appellants have the burden to establish. So what the trial judge did in this case is it imposed a sanction and it made a finding that Mr. Barillo had engaged in fraud upon the court by not disclosing this improper relationship, and so did Lindsey Eberhardt, who knew that she had this relationship with him and never disclosed this to the court at all. So they come back to the notion that, well, there was a whole proceeding regarding attorney's fees, about guardian's fees, and we had a full and complete opportunity to present whatever arguments we wanted to present. So let me remind the court what it did in re CW and BW decided in late 2018. It dismissed all of our assignments of error with respect to the improper procedure that was used to establish the guardian ad litem fees in the first place, this $17,400 attempt to get the Sherwoods to pay these guardian ad litem fees, because it determined that that issue was ultimately moot, because the court had in fact issued an order terminating the right to those attorney's fees, which by the way was never appealed by Mr. Barillo. When I say attorney's fees, I mean guardian ad litem fees. So the challenge that we already made to the improper procedure, which by the way we had no evidentiary hearing, no right to call any witness. What the court held was that we had a right to, quote, oral argument, which made no sense to me. I objected on the record. It's clearly in the record. And then we set forth our oral objections to these proposed attorney's fees. Then the magistrate made a decision about what the attorney's fees would be without any evidentiary record whatsoever. not even as much as an affidavit from the guardian ad litem, who we now know was engaged in an illegal, improper, unethical relationship with a party to the case. We didn't know that at the time. We suspected it. We told the court, we know there's something wrong with this relationship. There were just too many indications. But we didn't get any opportunity to present that evidence. And ultimately, after the court made its judgment, and while the case is on appeal, we discovered that not only is he writing briefs in this court that she filed on her own behalf, he wrote them. We see it from the metadata that he wrote them, and then he submitted, then she submitted these briefs as if they are her briefs. They're clearly not written by a pro se litigant under any circumstances. And then we found out that they're not only living together, but they're now engaged in this intimate relationship, which they have now finally admitted to. So then we filed our motion for relief from judgment, asserting quite correctly that this was fraud on the court and fraud on the Sherwoods, and that this whole entire judgment that related to attorney's fees or guardian ad litem fees was tainted by this awful stain of a lawyer engaging in this conduct without disclosing that relationship. And then in response, he files a brief, and it's right in the record, I pointed it out in my briefs, where he claims to have sent a letter to the trial court informing the trial court of his obvious conflict of interest, and that he should not be the guardian ad litem. The unfortunate problem is, not only did the trial court never receive this purported letter, but neither did any of the other counsel in the case at all. So I submit that was a fraudulent document. It was created to make it appear as if he had made a disclosure when in fact he made no disclosure whatsoever. And the trial court was fully informed of this fact at the point in time when it concluded that based upon everything that it had in front of it, a fraud had been worked upon the trial court and granted relief from the judgment. That is what this Court of Appeals is confronted with in this record. And I respectfully submit that this judgment should be affirmed. Thank you.
Okay, thank you. You have 3 minutes for rebuttal.
Thank you. I guess when the facts aren't supported by the record or have ever been the subject of an evidentiary hearing, and when the law and the issues before you do not support the judgment or result you want, I guess we're going to resort to just calling names nowadays. Mr. English has been riding this reprehensible conduct horse. Unfortunately, it was very successful in front of Judge Janik in this case. However, there was never a hearing on this illegal, reprehensible, unethical relationship as to when it started and to what effect, if any, it had. Rather than have a hearing, Judge Janik concluded that they didn't answer discovery, even though it may ultimately reveal an improper romantic relationship. And from there, he somehow concludes that since this relationship may be revealed, it must have existed. Those aren't facts, and they don't have anything to do with the jurisdictional issues in this case. Every time Ms. Eberhardt or Mr. Brillo wanted to have an evidentiary hearing on whether or not there was something improper going on here, Judge Janik never allowed it to happen. The issues in this case has gone on and on and on, and based upon this court's decision in Ray CW, there is nothing for the Sherwoods to assert, appeal from, or seek a relief from judgment from. The document that he keeps citing as granting the Sherwoods some sort of right to visitation has been clearly stated does not grant any such right of visitation by this court. It was not an exercise jurisdiction. It was unenforceable agreement between the parties. Unfortunately for Ms. Eberhardt, she didn't realize that at the time, or she could have just merely withheld visitation, and then that would have been the end of this. Likewise, the decision rendered by Judge Janik finally granting some sort of visitation has been vacated by this court. So that there is no underlying judgment, there is nothing to appeal from, there's nothing to seek judgment from, and in light of that, Mr. English is just gonna scream that they must have been right, the court must have been wrong, because at some time after Mr. Gorilla was discharged to the GAL, he entered into a personal relationship with Ms. Eberhardt. For that to have any effect, it should be in the record, but unfortunately, Mr. English has no problem with casting aspersions that aren't supported by the record in any case, in an effort to cover the pitfalls in all of his arguments. And in light of that, again, I respectfully suggest these issues are moot, and the sanctions should be vacated, and this horse should be declared dead once and for all, so they can't be ridden any further. Thank you.
All right, court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail each counsel a copy of the decision on the day it's released. The opinions are also posted on the Supreme Court of Ohio's website. The court has nothing else before it, so we will